Welcome to Spoken Injustice, where we put the criminal justice system in the dock. If you recall, in our opening note, we referred to some issues which we deferred for discussion to a later date. Since we have temporarily paused our trial, it seems an appropriate time to discuss these now. And one of them, as you recall, is jury trials. In this video, first we're going to look at jury's constitution and role, then highlight some of the criticisms of the jury system, and finally look at possible scope for reform. So do buckle up and follow us until the end. As you probably know, a jury generally consists of 12 members of the public, aged between 18 and 75, randomly selected from the electoral roll. From these, some are excluded and may be disqualified if, for example, they are currently on bail, they have been on probation, or are serving or have served imprisonment or community service sentences. Jury are responsible for determining the facts of the case and delivering a verdict. The judge, on the other hand, provides them with legal guidance and instructions. The principle behind jury trials is that a defendant is entitled to be tried by their peers. The jury's role is to listen to the evidence presented in court, assess its credibility, and reach a verdict based on the facts presented in court and the application of the law as instructed by the judge. The aim is to have a fair and impartial assessment of the case by a group of ordinary citizens. Sounds great, simple affair, right? However, jury trials are not without potential flaws or criticism. But before we embark on examining some of the flaws and criticism of the jury system, I have a little favor to ask. If you find our videos useful, please like and subscribe. This may seem a small action to you, but it has huge consequences for us, as it helps us grow our channel and ultimately our audience. As the greater the numbers of likes and subscribers, the greater opportunity we have to reach more users. Thank you. So when it comes to jury trials, it is important to note that though jury trials are used only in a small percentage of criminal cases, with most criminal cases in fact being resolved at magistrate's court or resulting in guilty pleas, those cases in which the jury deliberates are the most serious ones, and those that attract the most serious sentences with severe consequences for the accused. Therefore, it is paramount that any flaw or criticism is appropriately addressed and, whether possible, remedied, rather than having a complete faith on the jury system based solely on the facts that it is an institution that has stood for many years and solely in the name of the principle that a defendant is entitled to be tried by their peers. So let's identify and address common criticisms and flaws that those who are not great supporters of jury trials have raised. So the most common criticism is that jury trials are slow, convoluted, and expensive. Though undeniable, jury trials do constitute a burden on the taxpayer's purse and at times slow the criminal justice machine, one can argue that perhaps this is a price worth paying if it means that justice is done and delivered by peers rather than being imposed by the state, and it's fair. Is it fair though? In reality, there are other criticisms that are more concerning. One of those is that the random selection of jurors means that their level of understanding and processing of facts may vary greatly, and that there is currently no way to judge their ability as there is no screening, and we are solely rely on self-certified assurances that selected jurors can basically read, write, and understand the English. Therefore, the criticism is that the complexity of some cases may be too difficult for some jurors to fully grasp. Those who support jury trials say that there are processes in place to compensate for these potential flaws. For example, judges' instructions are said to be in place to compensate for example, the jury's lack of legal knowledge and understanding. However, in my experience, judges' instructions vary greatly in details and clarity. In addition, they are mostly limited to the law, so this leaves out some of the complex facts that affect certain trials, which, unless jurors are particularly versed in, could result in serious judgment errors. Some concerns that have been raised include the possibility of jury biases. Again, supporters of jury trials say that the fact that both prosecution and defense can challenge potential jurors during the selection process is said to be a good safeguard to minimize biases. However, it is impossible to know whether jurors will answer questions truthfully, and this process is so limited to a few questions at the beginning of a trial, which seems to be in place more so that justice can be seen to be done rather than justice being effectively done. Another concern is the potential influence of media, social media, on jurors' opinions. The media's role in potentially influencing jurors and the impact it can have on a fair trial is a complex issue. One concern is the possibility of jurors being exposed to prejudicial media coverage before or during a trial. Biased or sensationalized reporting can potentially influence jurors' perception, making it difficult for them to remain impartial. For example, in the case of Sally Clark, it was believed that the news headlines describing the chances of 2 children from an affluent family dying of cot death being 1 in 73 million made such an impact on the jury that obscured completely the defense position that they never asserted that the boys in fact died of cot death. In fact, as it transpired in the end, they did not. A jury made up of randomly selected qualified doctors may have come to a completely different outcome. Of course, there are laws regarding contempt of court which aim at preventing the media from publishing prejudicial material that could interfere with the ongoing legal proceedings. Journalists and media organizations can be held accountable if they breach these rules. However, experience teaches us that these are rarely enforced. And what about cases which are retried after a successful appeal, particularly those that have been subject to extensive sensationalized coverage post the first trial, by both media and social media, which are not covered by the contempt of court offences. The rise of social media has added another dimension to the issue of media influence on juries. Jurors' online activity and discussions related to a trial can potentially compromise their impartiality and the integrity of the entire trial process. Those in support of jury trials says that offence under the Jury Act 1974 and offences of the contempt of court are sufficient safeguard in this respect. Furthermore, they say the range of offences which a juror can commit in relation to a trial was increased with the introduction of 4 new offences into the Jury Act 1974 by the Criminal Justice and Court Act 2015, which include the offence of actively searching for details of a case online. However, given the principle of jury secrecy, discovering, detecting, proving and enforcing such misconduct is extremely difficult unless they are brought about by other members of the jury. And what about pop-up news and social media groups the jurors are part of, which are not actively pursued, but just happens to appear in a juror's phone spontaneously and unsolicited? Furthermore, academics who have researched past cases of jurors' misconduct have come to the conclusion that a distinction needs to be drawn between jurors' ministerial and judicial duties. Ministerial duties are those related specifically to the office jurors serve, such as coming to court on time, not leaving court unless with the permission of the judge, as opposed to those judicial duties related specifically to the strict act of deliberation. From the analysis of past cases, academics have come to the conclusion that whilst judges are more willing to take action where jurors have breached their ministerial duties, they are more reluctant in intervening when the breach relates to their judicial duties, for fear of interfering with the principle of jury independence. We will look at jury secrecy and jury independence shortly, so please stay with us and like and subscribe if you're finding this video useful. Many, including esteemed academics, believe that a small change could resolve most of this issue, and we tend to agree with them. We believe that a way to maintain jury trials' advantages, particularly the independence from the state, and at the same time to resolve any doubt as to possible biases or errors in fact finding, is to impose upon juries a duty to provide reasoning for their verdict. This would, in our opinion, also strengthen transparency and fairness and increase confidence in the criminal justice system. However, there are at least 2 principles which are in effect the opposite sides of the same coin that are seen as an impasse to juries' reasoning. These are jury equity and jury secrecy, which also encompasses jury independence. In the UK legal system, jury equity refers to the discretionary power of a jury to deliver a verdict based on their sense of justice and fairness, even if it goes against strict legal rules or the judge's instructions. It allows the jury to consider not only the facts of the case, but also the broader moral and ethical implication. This principle is intended to ensure that the law is applied fairly and justly, taking into account the community's standards and values. However, it is worth noting that the concept of jury equity has evolved over time and stemmed from a famous case known as the Bushell case. It is a significant case in the history of jury independence and the right to deliver a verdict free from interference or coercion. Bushell's case occurred in England in 1670s during the reign of King Charles II. It involved William Penn, a Quaker, and William Mead, both of whom were charged with unlawful assembly and rioting for holding a religious meeting. The case is named after Edward Bushell, one of the jurors in the trial. During the trial, the judge attempted to exert control of the jury by directing them to find the defendants guilty. The jury refused to do so, and the judge first subjected them to 3 days of starvation, and when they still returned a no guilty verdict, he committed the entire jury to Newgate prison. However, despite the judge's pressure, the jury acquitted Penn and Mead. This verdict was seen as a significant assertion of the jury's powers to deliver an independent verdict based on their conscience and interpretation of the law. The case established the principle that a jury should be free from any intimidation or coercion and should be able to deliver a verdict according to their own judgment. It affirmed the idea of jury independence, emphasizing the importance of jurors being able to make decisions without the fear of punishment for reaching an unpopular verdict. The Bushell case has had a lasting impact on the development of jury rights and the preservation of jury independence in both the UK and other common law jurisdictions. It is considered a landmark case in the history of jury trials and their role in safeguarding individual liberties. However, jury equity was more prominent then, where juries had significant discretion to interpret the law and deliver verdicts based on their own sense of fairness. However, with the development of a now more standardized rule of law, should we not focus more on the application of the law rather than individual notion of justice? Do we really want to allow 12 randomly selected people who may not on occasion represent society in its entirety to be above the law? Let me know in the comments below. As per the jury deliberation secrecy, also known as the rule of jury secrecy, is said to be in place to encourage open and honest discussion amongst jurors about arguments and evidence presented at trial without fear of external repercussion and pressures, thus protecting their safety and anonymity. However, if the reasoning is given as a global reasoning without pointing to any particular juror, I do not see how this argument could stand, particularly if the price is that of sending an innocent person to prison or letting a guilty person free. Also, the principle of The principles of jury secrecy and jury equity sit uncomfortably with the oath jurors take at the beginning of a trial to try the case solely according to the evidence they hear at court. It's important to note that while jury deliberations are confidential, jurors are required to follow legal instructions, base their decision on the evidence as presented in court. The reasoning will shed light as to whether the decision-making process has effectively taken place within the boundaries of fairness, independence, and integrity, leaving no doubt or second guessing. So, in conclusion, there are those who argue that jury trials can lead to inconsistent outcomes and may not always be representative of the wider population, and wish that jury trials are abolished. On the other hand, there are those who believe that jury trials are an essential safeguard against potential abuses of power by the state and wish to be maintained in their current form. We at Spoken Injustice support both arguments and believe that imposing a duty of reasoning upon juries constitutes a fair compromise. And where do you stand? These are undoubtedly complex issues, but we hope we have fairly represented both sides of the argument and are curious to know what you think. And so we encourage you to let us know in the comments below. We also welcome you to join our networking hub at spokeninjustice.net to actively participate in the debate of the most recurrent dilemmas in the quest for justice. Join us next week when we will talk about eyewitness testimony. We look forward to usher you as we sit and rise in this unique trial.